Hi, Kevin.
Hello, Rebecca.
Can you believe it? We're back for another what?
Readathon.
That's right. We are in the Readathon because today, an ocean of motions.
An ocean of motions. I love it.
Was filed for Judge Beverly Cannoni's deadline for, pretrial motions. Mm-hmm. There are so many that I want to kind of go through them. Of course, as of this taping, none of them have been issued orders on them yet. So I'd like to just go through what the defense and the Commonwealth are asking for at this eve of trial moment.
All right.
The trial right now, of course, is scheduled to start on April 1st.
Yeah, we're coming right up on that, aren't we? Okay.
That's right. So I'd like to start with motions filed by the Commonwealth. Of course, that's the prosecution.
Mm-hmm.
All right. So do you want to read this one for me?
Motion for sequestration order and relief from order for family members of the victim.
That's right. So I haven't read this one. That's why I say it speaks for itself. But it appears as if the Commonwealth is asking for a motion to either sequester the jury or sequester witnesses. But they obviously want John O'Keefe's family to not be sequestered. When I say I haven't read it, I mean it hasn't been, the text of it has not, as of this taping, been put out online, but everything else that I have here has. So I just want to do that one first, all right?
Yeah, you're right. Because usually if you're a witness, you're not really allowed to be a spectator. So they look
there's something about that too.
Oh, okay, all right.
Hang on to your hat. Read this one.
A motion to preclude reference to any alleged bad character and any prior misconduct of the victim and or witnesses. All
right. So here the Commonwealth is asking for nothing bad to be said about somebody like, say, Chris Albert, who was in a drunk driving accident many years ago and killed someone, that kind of thing. So they basically want no prior bad acts of victim, John O'Keefe, or any of the witnesses, especially their witnesses, in the trial to be brought in.
Do you recall whether that information was allowed in the first trial?
I don't think so. Well, I'm getting to why it's important, but I don't actually remember. I don't remember them asking questions about bad acts, so that's where we are with that.
All right,
read the next one.
Motion to prohibit reference to any pending internal affairs investigations, sustained findings unrelated to his case, or unfounded allegations of misconduct. Who is he? Is the victim?
That's this case.
This case. Okay, yeah. Note, they also want reciprocal discovery on any intended impeachment evidence against the like relating to law enforcement. Okay.
Yeah, so that was my note, by the way. So obviously they want to not have Fanning's IA investigation brought in, Proctor's IA investigation gone in.
How can you not? Yeah.
They don't want investigations relating to like the Sandra Birchmore case to come in, or other investigations that any of these officers were a part of.
Yeah, okay.
All right.
Can't imagine. Well, I was going to say, I can't imagine a regular judge saying that that's okay, but all right.
Here's a big one.
Yeah.
Go ahead and read that.
Commonwealth motion to preclude the defendant from raising a third-party culprit defense.
That's right. Yeah. They want to prevent Karen Read and her team from being able to float the idea, even in their opening and closing arguments, that somebody else could have committed this crime. So they call this defense confusing, prejudicial, and they say that Read isn't going to provide any proof of said defense. And the law says if you're going to raise such a defense, you also have to provide evidence of that defense. But that's a big one.
Yeah. I felt like they did, but okay.
Yeah. So this is the next one. Commonwealth
motion to obtain Corey records, criminal records of potential jurors. Appoint stenographer, prevent identification of jurors, and impound juror names during trial.
Right. Impounding the names is expected. Preventing identification is expected.
Sure.
Appointing their own court transcriptionist. I don't understand that, but maybe they always do that. I don't think they do, right?
I thought that the court provided
a
court reporter.
Exactly. And he says he'd like to see any criminal records of any potential jurors that he will then disclose to the defense. Next, this is an interesting one.
Commonwealth's motion to allow in-court identification, introduce certified records from the Registry of Motor Vehicles.
So they want witnesses or friends of Karen Read who are on the stand, or people who knew Karen Read who are on the stand, to be able to say, that's her. Point and say, that's her. So let me tell you what I think might be weird about that.
Okay.
The pointing to the defendant and saying, that's her, is a signal of guilt to jurors. That's something that is known by prosecutors, and they basically want people to prove that they know this is Karen Read, i.e. the only defendant sitting at the defense table. Okay?
Yeah. Well, I mean, the prosecution is required to identify the suspect as the culprit or the perpetrator. And usually do you see the person in the courtroom today? But they want a big show of it?
That's right.
Okay.
Next up from the Commonwealth.
Requesting use of chalks and directing both parties to provide visual representations and chalks prior to using.
So what they want to happen, and actually there's a very similar motion from the defense relating to the same thing. They want to make it so if you are talking about data, talking about something complicated, that there must be a visual representation, a chart, or something like that, so that the jury can better understand what people are talking about. Does that make sense?
It does.
And they say they plan to use surveillance video, photographs, videos from crash reconstruction, videos from the reconstruction at 1 Meadows Avenue, diagrams of scene, etc., etc., etc. Next.
Motion to allow expert Cellbrite demonstration.
They would like their Cellbrite expert, Ian Whiffen, and the Commonwealth's technical expert, Jessica Hyde, to demonstrate how phone data was stored and then obtained. Mm-hmm. So they basically want Ian to be able to say, I demonstrate how he did it in court. Make sense?
Yep.
So next.
Commonwealth's motion to offer of proof prior to defendant calling or summoning the Norfolk District Attorney and victim witness advocate as witnesses, and request for an order that neither is subject to a sequestration order.
Right. So
they're afraid that they're going to call the DA as a witness.
They don't want Morrissey or the victim's advocate being called. They are citing lack of evidence for a reason they should be called and confidentiality of work product.
Why the victim advocate? Do you have any idea why that person is identified?
I don't know. Yeah. And this is something that a listener might know. I might want to clue me in on. And I looked through the filing, and basically, when the defendant resorts to, quote, extraordinary means of calling a prosecutor as a witness, he must make a, quote, satisfactory offer of proof of the need of that testimony. So they're saying that's not there. And plus, what's happening with these people is work product.
I think Commonwealth's going to win that one.
They very well could win that one. Yeah. All right. So, Kevin, let's move on to some defense motions, shall we?
Okay, defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence.
All right, this one relates to the Aruba testimony. Remember the Aruba testimony?
There was a fight, and this was between Karen and John when they were dating, and another couple, and there was that whole tawdry
She thought
thing.
He was macking with another girl.
Yep.
She was mad at the other girl. It was a whole ugly fight. What they are saying is that is irrelevant, and they don't want witnesses only called for the purposes of attempting to show some sort of hostile relationship between John O'Keefe and Karen Read, long before this incident.
Right, okay.
Because all the witnesses said, even the Commonwealth's witnesses, that they seemed to be getting along really well the night of the incident.
Okay.
Make sense?
Yep.
Next.
Defense motion to exclude false and irrelevant statements by Michael Proctor.
All right. This relates to a statement that Michael Proctor made in the trial where he accused David Yannetti, Karen's lawyer, of meeting with Lucky Loughran in a school parking lot where Trooper Proctor's sister Courtney worked. Mm-hmm. And Proctor claimed that Yannetti...
Of course his sister worked there, but go ahead. Yeah.
Proctor claimed that Yannetti went there kind of on purpose because she worked there, that he refused to leave when confronted, that he, upon being confronted, he asked about Courtney Proctor's whereabouts and whether or not she worked there. And these assertions are false. There is a police report from the time because the principal called the police and said they're in our parking lot. They haven't done anything, but it seems like there's a meeting going on in our parking lot. So the police went and observed, and they observed no approach of the school, no talking to anybody at the school. So this was a lie.
And this came up in the testimony.
Yes.
You said that. Okay.
Yeah. So basically he was trying to say that Yannetti, is basically taunting or something, his sister, by having this meeting. But no, it seems to me like they were just meeting at the school parking lot because that was a convenient place to meet.
Yep.
Make sense?
Yep.
Next up, go ahead.
Defendant's motion to present demonstrative exhibit based on Christina Hanley's testimony.
So this one is related to pieces of glass I allegedly recovered from the crime scene and from the bumper of Karen Read's vehicle.
Glass or plastic? No, glass because we think that there is a drinking glass thrown. Okay.
Right. And what this motion says is that because her testimony is complicated, involves lots of pieces coming from here and coming from here and coming from here, they would like her to use a visual aid, basically showing place and thing. So what they're trying to do is she has to have a demonstrative exhibit that makes it clear to the jury so that they can cross-examine her in a clear way.
Right. Okay.
Because she's a Commonwealth witness.
Gotcha. Okay.
This one's interesting.
Yeah, the prosecution, the Commonwealth is saying, like, if you want to bring in chalks, which are...
It's very similar.
Yeah, right. So, okay. Goose and gander. This is one from the defense. Motion to allow evidence of lack of bias.
That's right. So what this means is that they want Judge Cannoni to allow them to say that the feds hired ARCA.
Oh, okay. So that's all right.
This goes on to say, it says exactly what you would expect, that a juror giving an interview to Vanity Fair said they had no idea who ARCA was hired by.
Yeah, we've heard that from more than one juror.
And they thought that, that's on the record, and they thought that, maybe it was her insurance company or whatever. And so they want to be able to say, this actually goes to the credibility of these witnesses. They want them to be able to say they were hired by the feds, and they worked with the FBI, et cetera. So that's what this big motion is all about.
Yeah, and I wonder what the counter argument is going to be at this time if the federal investigation is over, other than just, well, I don't know. I guess we'll see when the Commonwealth files their response.
That's right. Next up,
a motion to prohibit testimony regarding funds paid to experts for the purposes of voir dire.
So they don't want experts to have to disclose if they were paid fees and travel for their testimony, because what they say is that leads to you're not qualified, you're a hired gun cross-examination, which, a lot of the experts for the Commonwealth work for the Commonwealth.
Right.
So it sort of gives the Commonwealth an advantage in terms of their witnesses because they weren't hired, they didn't pay fees, et cetera. So that's what they would like to be able to do.
That seems like a sort of a standard procedural thing. Obviously, all defenses they bring in expert witnesses, so it seemed like there would be some sort of judicial rule already around that.
There are a lot of things that I'm surprised there aren't judicial rules around, and we'll get to some of them. So here's another one.
Okay.
You ready?
Yeah.
This one was actually filed as we were taping.
Okay.
Or the text was posted as we were taping.
I guess it's glad I'm reading a little thing so your attention can be drawn to your phone.
That's right. This one is the defendant's motion to allow counsel to state grounds for objection to promote judicial economy and efficiency and to adequately preserve issues. So, Beverly Cannoni has said multiple times in Massachusetts, you can ask for an objection without stating a reason. And the defense would like to make it so they have to state a reason for their objection, because what happened over and over and over again in the trial was that someone raised an objection and there would be a lengthy sidebar. Explaining the objection, blah, 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 blah. So they just want to be able to do that.
It's funny. You don't need to explain it, but come over here and take 20 minutes to explain it to me.
That's right.
Okay.
So I think that is fair in my opinion and makes sense.
Yeah.
Next up, go ahead.
Motion to exclude serum plasma, ethanol concentration, and the like.
So that is a basically an extrapolation of the very long name of this motion. The Commonwealth, by the way, has filed an opposite motion to admit the results of the hospital blood draw and the resulting extrapolation. So what this relates to is that the defense is saying any claims that the state is making about Karen Read's blood alcohol content are not provable because it was blood drawn at a hospital. And then what happened was the state's experts used an extrapolation process to be able to say, oh, this is this, therefore this is this. But the blood was never in the hands, the blood itself was never in the hands of the Commonwealth.
Okay.
So they want the blood alcohol stuff out because the blood alcohol stuff was done at the hospital, and the Commonwealth filed an opposite motion.
Kind of a chain of custody kind of thing.
And they want, you're going to love this one.
Motion for review.
The defense wants a view. Want to explain what a view is?
This is where they go on a little field trip, and the jurors are taken to locations that are important to the case. So this is obviously going to be to the house.
That's right.
And in these things, that some places it's like they go before opening arguments so that they can take it in. The lawyers are not allowed to say, this is where that is, and this is where that happened, but they are allowed to say something. Please take note of the distance from the flagpole to the backyard or the whatever. They're allowed to sort of do that. Maybe they walk through the house. They probably are not going to go in the house,
right?
Even though that seems like it's really important. But yeah, that's going to be interesting. And they're going to have to block off a lot of the street because a lot of telephoto lenses will be out that day, my friends.
Guess what else they want?
I don't know. What do they want?
They want Karen Read's 2021 Lexus to be towed to 34 Fairview. for The View.
Okay.
Mm-hmm.
Okay, yeah, I can. They have a good objection to that. I mean, I don't. Is that really probative? I mean, where would they put it exactly? Where the prosecution says it goes? Now you're introducing evidence. That's not a view. Okay. Anyway,
I'm very interested in that.
That
was in the motion.
That was the defense wants that.
Yes. These are all defense motions that we're going through.
Interesting.
Right
okay, I don't get that, but all right. They see something with the sense of scale of that, I suppose.
I think what they're trying to do is counteract some of the reconstructions that the Commonwealth is going to.
Okay.
Like how big her car is, for instance, or whatever.
Okay.
The next one is also from the defense.
Motion for attorney-conducted panel voir dire of the jury.
Now, one note, the Commonwealth has filed a very similar motion, which you did not read in your list because I knew it was going to be put here.
Mm-hmm.
They basically would like, instead of Judge Cannoni to question potential jurors, they want to be able to also question potential jurors. As you know, voir dire is very often done just by the judge.
Mm-hmm.
They would like the attorneys to be able to ask questions of potential jurors, and they would, and then the Commonwealth has also added they would like a questionnaire be given to potential jurors.
Okay. That's not uncommon, and they have strikes too, right? That they can they can use.
Yes.
All right.
And they might think of questions that Cannoni, for instance, wouldn't think of.
Right. So it seems like they're both in agreement on that they would like that. So that probably means that the judge would acquiesce, but who knows?
Here's another one.
Motion for order prohibiting the Commonwealth and its agents from speaking with or having any contact with witnesses once they have taken the stand.
Okay, this happened during the first trial. In between Brian Albert's testimony and cross-examination, he spoke to Prosecutor Lally. And he said so on the stand.
Yeah.
And they actually give that example in the thing. Albert indicated he had spoken with Assistant District Attorney Adam Lally over at the lunch break while the court was in recess during the middle of his testimony. When asked what they had discussed, he initially denied speaking about the substance of his testimony, but then later admitted that ADA Lally had discussed some of the topics he wanted to ask him on redirect. That's bad.
Yeah.
That's bad.
That's bad. He knows better.
Oh, yeah. So basically they want a actual order saying once somebody hits that stand, you cannot talk to them.
Yeah.
That's right.
Again, it just seems like these ought to be like normal judicial procedures, but all right.
So this one I haven't read because they also have filed a companion order to impound it. So I'm guessing that they're not going to release the text of it upon waiting for the order whether or not it's going to be sealed.
Okay, so we have here defendant's motion to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. Is this Turtle Boy shit?
Turtle Boy shit and all that stuff. All right, Kevin. So this last one that I'm going to have you read is one of my favorite ones that they filed, that defense filed today.
Okay, it's called defendant's motion to exclude certain witnesses before and after testimony.
What do you think that refers to?
Is this to exclude from the courtroom?
Yes. This is so that Jen McCabe, members of the Albert family, cannot sit in court before or after their testimony at the trial.
Right. This is the defense.
Yeah, that's a defense motion.
Okay, yeah.
And also, I don't know if you remember this, a juror also went on the record with a journalist saying that Brian Albert sitting there was very intimidating during closing arguments.
Right.
So they think that it's prejudicial. They think it's improper for any witnesses in the case to be able to basically watch the trial from the courtroom or be present for the trial, looking at the jury, etc., during the courtroom.
Yeah, so it explicitly calls out Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins, but not the victim's family.
Not the victim's family. Of course, the victim's family.
Right. We have we have like motions that are kind of on the same topic between the Commonwealth and the defense, and they're sort of taking it from each point. But I'll just say, like, all the Commonwealth motions seem to go hard at every possible argument that the defense is going to raise.
Yeah.
Yeah, and it certainly seems like the defense is trying to shore up some of its points.
Yes.
But not sort of wholeheartedly saying you can't say this, you can't say that.
And they're trying to undo some of the orders that Beverly Cannoni gave for the rules of the first trial, such as the ARCA experts being able to say who hired them. This is stuff that is demonstrably going to make a difference if she allows it, because jurors said it would.
Yeah.
So it looks like they're trying to have basically a better second trial than they had a first trial. Now, Kevin, there may or may not be more motions being published in the next couple of days, but
we're still waiting on a bunch from last week, right?
We're waiting on a bunch of decisions.
The motion to dismiss. And
some of these decisions, these orders that Judge Beverly Canoni will give, will just be in writing. She'll just release it saying so ordered, denied, etc., right on the paper.
Yeah.
And some of them will be argued next week at an evidentiary hearing on the 18th.
Okay. Yeah.
So we're going to be back.
All right.
Giving you some updates about the big ones that were allowed, the big ones that were denied, etc. And of course, I will be watching that hearing gavel to gavel.
Of course.
I can't not do it. And those of you who enjoyed having Mel Barrett on the show yesterday, she has agreed to join me for some of the live trial coverage that we plan on doing when the trial starts, because like me, she also watches it gavel to gavel. But sometimes I have meetings and I need someone else to watch it. So anyway, if you like Mel Barrett, you're definitely going to be hearing from her again. Kevin, that's it for today.
All right.
Thank you so much for joining me for yet another action-packed Readathon.
And all those oceans of motions.
Oceans of motions. Talk soon.
Partners in Crime Media.